You own property, but your co-owner just sold their part. They didn't even tell you. Can they do that? In this video, we're going to talk about real property ownership rights and how we transfer real property. Property ownership takes various forms, from individual ownership to more complex shared arrangements, and understanding these different structures is fundamental to real estate practice. Severalty represents the simplest form. It's ownership of property by one individual or entity, but it's just one. However, when two or more persons own a piece of real property together, it enters into the concurrent or co-ownership stage. In concurrent ownership, the owners don't own a specific portion of real estate. Instead, they all own an undivided share or interest of the whole, and each is entitled to occupy the entire property. So let's get into this. The first form of co-ownership in real property is called a joint tenancy. It's a concurrent interest with all rights of ownership going to the surviving joint tenant or tenants when one of the other joint tenants dies. We say that they have unity of title. So for example, A and B each own a half of Red Acre as joint tenants. If B dies, what happens to the property? A gets it. It's an automatic transfer that goes to A, and A becomes the sole owner if we just have A and B. Our other form is tenancy in common. It's a concurrent interest with no right of survivorship. So when one of the joint tenants dies, the interest is going to pass to the heirs of the deceased owner, that interest. So for example, if A and B each own a half of Red Acre as tenants in common, if B dies, what happens to the property? It doesn't go to A, it goes to B's heirs. So both tenants in common and joint tenants can sell their undivided interests. They can lease their portion, they can mortgage their interest, and they can even transfer by will if we're talking about tenants in common only. I'm going to give a few more examples. I want to point out specifically that courts will treat a joint ownership of property, whether it's 2, 3, 4, or more people, as tenancy in common unless there is something in the deed that says that they are joint tenants with survivorship rights. It literally has to say survivorship in it to flag the court that this arrangement is a joint tenancy. Let's go through some joint tenancy problems and their solutions. Let's say we have A, B, and C. They're joint tenants of Green Acre. A sells his interest to D without the consent of B and C. What happens? Well, our legal rule is when one or more of the unities in a joint tenancy is destroyed, the joint tenancy is going to lapse with respect to that share. So in this case, B and C are still joint tenants, which means if B dies, C is going to get B's portion, or if C dies before B, B will get C's portion. But D becomes a tenant in common. And if D dies, D's interest is going to pass to D's heirs. Another example, if A and B own the land as joint tenants and A sells to D without B's permission, the whole joint tenancy is destroyed relative to each share. So if D dies, the land will go to D's heirs, and if B dies, the land will go to B's heirs, so that the relationship between B and D will be tenants in common. Another example, A and B own property as joint tenants. A makes out his will that upon his death, C gets A's interest in the property. And the question is, well, does A making out the will destroy the unity because they are joint tenants? And the answer is no, it does not, because B, as a joint tenant, would own the property automatically upon A's death. It's going to be automatic. There wouldn't be anything left for C. Another form of ownership is tenancy by the entirety. When this was created, it was between husbands and wives. Only half the states actually recognize it. It's kind of outdated, but it was created to protect women from being tossed from the home as a result of their husband's actions or their husband's debts. So the gist of this rule was to protect that. So it was an automatic survivorship rights that was created when two spouses bought property together as joint tenants. They were actually joint tenancy with right of survivorship. Both spouses will have to consent to any transfer of the property, not just one. There was creditor protection under tenancy by the entirety. Creditors of one spouse cannot place any sort of liens or satisfied judgments against the property. They must be creditors of both spouses. I mean, it happens, but they can't, when I say that happens, creditors who try to lien on a property where it's owned by spouses, they can't institute an action to try and take the house to get payment because there's the two spouses. That would not be the case tenants in common. If we had two people that own a house as tenants in common, they weren't married, they just had the property. Divorce automatically converts ownership of any property that the two spouses, initial spouses, own as a tenancy in common. So it would break the tenancy by the entirety and the rules would no longer apply. Let's talk about nuisance. It's a tort claim that a property owner can have against another property owner. Rosa and Sam are neighbors living in rural Northern California. On her property, Rosa plants grapes and she begins operating a vineyard and winery. A few years later, Sam, who operates a small gravel pit on his land, wants to enlarge his business. The expanded excavation will throw more dust in the air. There'll be large trucks. There's other equipment that are going to come and go from Sam's property. And the increased dust and vibrations is going to harm Rosa's agricultural operation. And the question is, can Sam use his property as he sees fit, regardless of any effect on his neighbor's property or even business? And this is where we have the law of nuisance. We are all entitled to use our land, quiet enjoyment of our land as we see fit per any restrictions that are in the deed. But what if you have a neighbor that's interfering with that? A person can bring a claim of nuisance against their neighbor. If they do, they have to prove that their neighbor, the defendant, is causing a substantial and unreasonable interference with the claimant's land or his or her enjoyment and use of that land. It could take a long time to prove such a case. Most folks go in and ask the court for what's called an injunction, a preliminary injunction preliminary injunction to get them to kind of stop temporarily until the court can actually make a full ruling for an order or an injunction that permanently stops the operation. Can take a long time to get the permanent one, but if Rosa can show on a preliminary basis, might be able to get a preliminary injunction here. But it is a law that's used quite often. Property owners against their neighbors who build big fences and it blocks the view of the sunset and things of that nature. Ownership of real property can pass from one person to another in a number of ways. So let's talk about those ways that we transfer property. Commonly is we sell it. We transfer by sale, but we can also get property as a gift. We can get it in a will, inherit the property. Let's talk about sales. If the property is sold, the specific terms are specified in a contract. The contract has to be in writing. Now, not every contract has to be in writing. Per contract law, you can have an oral contract, but per the state's statute of frauds, there are 5 types of contracts that must be in writing, Any contract involving real estate or an interest in land must be in writing. That's why our easements needed to be in writing. That's why our sales contracts need to be in writing. The basic terms, the subject, the piece of land described, not just the address, the description of the property, who are the parties, how much, and both signatures need to be on it to be a valid contract. How do we transfer ownership rights? By deed. We have a warranty deed, we have a quitclaim deed. A warranty deed, the seller makes certain warranties providing the greatest amount of protection for a buyer against any defects in title. When a seller passes a warranty deed, they are providing maximum protection and legal assurance to the purchaser. If there are any defects in the title that are found out later, the seller can be sued and on the hook for fixing any of those defects. Examples of defects, this is not an exhaustive list, but common. The grantor doesn't actually own the property. Let's say the grantor is trying to sell property they claim they own, and in reality they only have a life estate. They don't have the full transfer. They could transfer their life estate, but the buyer seems to think they're getting it free and clear. Any unknown liens on the property or an encumbrance may exist. Errors in documentation or the legal description of the property. Fraud, forgery, any unclear, what we say unclear chain of title, like there's a skipped sale somewhere, or somebody gave the subsurface rights away and that's not documented in a chain search. A quitclaim deed provides the least amount of protection against defects in title. Basically, it conveys whatever interest the grantor had or has. So if the grantor has no interest, the grantee receives no interest. What is warranted in a warranty deed? Basically, the seller, the grantor, is conveying or saying or warranting that they have valid title and the legal right to convey the property to the buyer. And they're also warranting that the property is free from any encumbrances except those specifically disclosed in the deed. So a lien, maybe they had work done on the property, a new roof on the house, and they didn't pay the bill. Contractor may have put a lien on the property. Judgments, let's say they didn't, the seller didn't pay a credit card and they were sued and the court awarded the credit card company a judgment in the amount of $10,000. That can be presented against a piece of property and can be an encumbrance. Any easements are encumbrances as well. So all of that has to be disclosed. They also make or grant our buyer with the rightful claim that they will not be disturbed. So covenant of quiet enjoyment. Neither the grantor nor any third party with a rightful claim will disturb the grantee's possession. An example would be a neighbor who claims there's a boundary line dispute. I own this flower bed, but it appears to be in the deed that's being conveyed. But that would be something that would disturb the quiet enjoyment of the land. An example, Olive conveys Blackacre to Paul by warranty deed, but there's still an unpaid mortgage on Blackacre. Did Olive breach the warranty? Well, yes, because Olive must either disclose the mortgage or pay it off before conveying a warranty deed. A quitclaim deed is a deed intended to pass title, interest, or claim that the grantor may have in the premises, but not professing that such title is valid and not containing any warranty. So, as I said, this type of deed provides the least amount of protection against defects in title, and it basically conveys that the grantee, whatever interest the grantor has or had. If the grantor had no interest, the grantee receives no interest. Common uses of a quitclaim deed, because they do have their use. We see them in tax sales when a property is taken by the government and then sold for unpaid taxes, what a person will receive is a quitclaim deed, because the government can't give any assurances relative to the property itself. We see this in divorce actions. Two spouses own property. One wants to keep the property. The other spouse will issue a quitclaim deed to the other spouse. Easement transfers is when we see these right-of-ways. They're done this way in a quitclaim deed. They'll be added to the deed, but the deed will be a quitclaim deed. Adding someone to a deed. Say you own a piece of property and you get married and you want to add your spouse, you do that by a quitclaim deed. Property can also be transferred by will. Somebody dies with a will, they can name that person who gets or people who get the property. If somebody dies without a will, then state inheritance laws or intestate laws will designate who the property goes to. A lot of times in estate planning, people will they will redo their will, rewrite their will. It would be a quitclaim deed, and they would add themselves as having a life estate or a life lease. And upon the death of the last surviving spouse, the remainder men are usually the children. The property would pass to the children, and this prevents having to go to probate court relative to that piece of property. Real property can be acquired for free. And by free, you might have to pay a court, get a court order to say it's your property, but you don't have to pay the rightful owner. This concept of adverse possession. What is adverse possession? It's the acquisition of title to real property by occupying it openly without consent of the owner and for a period of time that's specified by state statutes. There's no delivery of a deed by the owner. Title is going to be acquired through occupation alone. If you want a deed, you have to go to court to get one. So the adverse possessor must obtain a court deed or judicial deed after bringing what we say is called a quiet title lawsuit. States vary dramatically relative to the time required that you occupy the property. In New York, it's 10 years, while New Jersey, it's 60. So in somewhere, some states are 30, 35, 20, 25. So it can be a very long time occupying this property. So let's talk about some of the elements that one would have to show. If the following conditions are met, there's 5 conditions altogether. The adverse possessor is vested with title to the property. These requirements work together. They want to ensure that a legitimate claim is being made, but courts want to protect true property owners. I think that's why New Jersey is 60 years. They don't like having to give away somebody's property. So let's talk about these. First up, statutory period. The time period varies. I already said that. It's named in the state statute. The clock, though, starts to tick when the possession begins. If the true owner finds somebody that's on their property or there's an issue, they have to commence what's called an injectment proceeding before our clock runs out. So for New York, our clock is 10 years. The clock starts to tick. The true owner wants to challenge the potential adverse possessor. They have to bring an action in court. The second requirement is actual and exclusive possession. The possessor must take sole physical occupancy of the property consistent with normal use. So they must enter the land and make active use of it. Now, I'm going to give you some examples. As simple as cattle grazing on the land. Building a structure. Let's say your neighbor built a shed and a portion of it is now onto your property. And you know it and you're looking at it, but you don't say anything about it, and it's been there for 15 years. You sell your house, the new owner comes in. That neighbor might have a claim for adverse possession. Your neighbor starts mowing a little section of your land and you're like, I'm okay with that because I don't want to do it. And they do it in New York for 10 years, open and actual doing it regularly. That can result in a adverse possession claim and then ultimately loss. They start making improvements on a particular type of land, growing a garden in that area. It's not just here I come and I'm just going to plop myself here. That could be it, but there's many other subtle ways where this occurs. The third requirement, the possessor must use the property openly, visibly, and notoriously. Basically, they're so conspicuous that the owner can be presumed to know. It's not a big secret. It gives reasonable person notice. What would give a reasonable person notice? Occupying the land, building a house on it. Oh, look, there's cattle in the field. It's obvious. It's got to be open and visible. Our fourth requirement is continuous and peaceful, that possession, for the specific amount of time. That possession must have happened without any sort of interruption. So a possessor must not have been interrupted in any way. For example, by the true owner, who starts an ejectment proceeding. Can a possessor leave and come back, continuing the clock? And the answer is no. If they abandon their possession and then go back to that possession, it's going to restart the clock for them, that 10-year period. We're talking about New York. The death of the possessor, what if the original possessor dies, but the heirs continue to possess the property? Does that start the clock over? No. As long as it's continuous. There's no break in the action. What if the original owner dies and leaves property to heirs who want to then remove the adverse possessor? Well, the time clock isn't going to stop because there's a different owner. The time clock is still going to tick. So the heirs may be in trouble if that statutory period has already passed, or any new owners, the original owner sells to a new owner. That does not break the clock here. So the clock will still continue. The last requirement, hostile and adverse. The possessor must claim the property against the whole world. It involves possessor's intent and the relationship to the true owner. So let's break this down. The possession could not have occurred or cannot occur with the permission of the owner, and nor can the possessor have ever had permission to be on the property. So think of like landlord-tenant relationship, right? The possessor starts out as a tenant, they have the permission of the owner, and then they overstay their welcome. That can never turn into an adverse possession. Intent of the ownership, the possessor must indicate clear intentions of ownership through their actions and behavior on the property. So building that shed that just kind of encroaches upon the neighbor's spot, there's a clear intention that there's going to be ownership. They're claiming ownership there, putting their cows on a piece of land. Adverse possession does not occur when possession started as a co-tenant, and it's not satisfied if the possessor acknowledges the other's ownership. So if there's acknowledgement, then we're not going to have adverse possession. And I do want to note, hostile doesn't mean aggressive behavior. It means possession that is contrary to the owner's right and without their permission. Kate and Leo own adjacent commercial buildings in which they operate different businesses. Kate's Culinary Arts is a cooking school, and Leo's Coast to Coast Shipping is a truck and transport dispatch service. Kate believes that she owns the parking lot behind the buildings. For more than 30 years, she has paid the taxes on the lot, posted signs claiming its exclusive use for her students, and towed away vehicles that did not belong to those students. Leo always believed that he owned the lot, however, claims he has never expressly consented to Kate's use of the parking lot. Finally, Leo decides to challenge Kate's possession of the parking lot, and the question is, who wins this adverse possession dispute? Does Kate use this more than the statutory period? If we're in the state of New York, yes, because it's only 10 years. Has she used this property openly and notoriously? Well, would a reasonable person think so by seeing her signs hanging up and towing people away who are using the lot? And how about paying the taxes, right? That should be a big claim. Is she using it actually and exclusively? Sure she is. She's posted the signs that says nobody can park here but her students. Continuous and peaceful? Yes, there's nothing in here that says otherwise. She never abandons the property in any way, and she is using it hostile. The definition of hostile here. She doesn't have permission, right? She never got permission. There isn't permission here. She didn't have it initially. So here it looks like Kate's going to win. One final way that property gets transferred is by eminent domain. Even ownership in fee simple is limited by a superior ownership, the government. Whether it's federal, state, or local, they have the ultimate ownership right in land. This power is found in the U.S. Constitution that says the power of the government to take land from private citizens for public use as long as they pay just compensation. So let's talk about this. What constitutes public use? Well, traditionally, we had highways, schools, or other direct government facilities that serve a general public. However, the U.S. Supreme Court has held that the government can take private property and transfer it to private developers for economic development purposes. And there was a big outcry when that case was going on in Connecticut, Kelo versus the City of New London, that expanded that definition of public use. It became one of the most hated cases that came out of the Supreme Court at the time, 90s, late 90s, I believe, early 2000s. So another example could be a private company wanting to run a natural gas pipeline across 200 plus properties. They can seek government assistance when an owner refuses or consents to sell them the property. They can use the government to come on in and take that property. The taking process, or condemnation is the fancy term. When the government determines they need land for a public purpose, they'll start a formal legal process to acquire the property. So the government determines or identifies the land that's needed. They determine the scope of the taking required. They begin the proceedings. Let's say it's a local town. The board will vote on whether or not they're going to take title to the property. Usually they may try and work something out first with the property owner to see if they can get consent and agree on a price for sale. Sometimes that happens. If not, then the proceeding will start and there will be a vote, and then there will be a separate proceeding to determine what the fair market value of the land is to ensure that there is quote unquote just compensation. But I will say in the state of New York, the local government picks the appraiser, and that appraiser's amount is, that's it. That's the price, the fair market value. The owner couldn't come in and say, I want to get my own appraisal. It doesn't work like that. And as I said, each state has a specific statutory process that this goes through. And if the property owner doesn't want their property taken, they're the ones that are forced to go to court to stop it. And it would require the government to come in and prove certain things. One, their public purpose. Two, whether in New York, what they're doing is going to affect the environment in some way. And three, if they believe that, this particular property or area is what they say full of blight, or it's blight. We don't need to go into all of the details there. The point of this discussion is that the government can take private property through eminent domain, and that it's outlined in the Constitution giving them the power to do so. So that concludes our discussion on property ownership and transfer of property.